and just admitting a few more people. Great. So I'll get started, and I'll quickly introduce myself, my organization, and give you a rundown of what we'll be talking about today. So as I said, for people who've just joined, my name's Stephen Abbott-Pugh. I'm the Data and Technology Manager for Open Ownership. Open Ownership is an organization that has worked with about 40 or more governments all over the world, and is focused on beneficial ownership, transparency and beneficial ownership publishing. So helping people to produce and release high quality beneficial ownership data and then be able to use it. And we're very excited to be working on a project in Kenya at the moment that we've been working on since last October, and we'll be carrying on through this year. So the purpose of today is to talk a little bit about some of the work that we are doing, to then hand over to my colleagues from the East African Tax and Governance Network, who are based in Nairobi, and who will be talking us through the legal landscape and some of the changes that have happened in this space over the last few months as we've been working on this area. We're then very pleased to be joined by representatives from GIZ, Transparency International Kenya, and also from Development Gateway in Kenya, who've been working on issues around beneficial ownership and also around open contracting, which relates to public procurement. And they're going to be talking about the work that their organizations have done, and then also sharing some of their plans for the future and some of the opportunities and the challenges that there are around this space in Kenya at the moment. After that panel session, we'll have a question and answer session towards the end. So please, if you have any questions throughout, if you please post them in the chat bar, then I will try to pick them up, or the other speakers will try to pick up on those questions. If you have ones specifically, you can wait hopefully till the Q&A session at the end. So if you keep some of your questions there till the end, I hope all the panelists and everyone will still be around then, and we'll be able to answer some of your questions and then draw to a close. So yeah, thank you again very much for joining us today. So just admitting some more people, to take a step back and to talk about beneficial ownership and public procurement. So for people who aren't aware of some of these terms, beneficial ownership refers to the real people who benefit from owning companies and other entities, and people who exert kind of ownership or control of those. They're not necessarily, they're different from the legal owners of businesses, but it's basically the people who benefit from an organization or a business. So it's the idea that there can be chains of ownership that lead back to a particular person who is then seen as the beneficial owner of a company or of something like a trust or something else like that. And the work that's being done all over the world at the moment, and it's an area that's of increasing interest to lots of people in different areas, is how to connect this data and information about who really owns companies and who benefits from companies with public procurement. So who really owns the companies that are benefiting from public procurement and are winning public tenders. Globally, about 12% of global GDP in 2018 was spent on public procurement, and with lower income countries spent an even higher amount than that in their economies. So there's a huge amount of the economy that is organized and spent through public procurement bodies and tenders. And my organization has carried out some research that I just wanted to share with you and to talk about today. We've produced a paper on beneficial ownership data and procurement, which I'll share in the chat after this. It's one of the things that's attached to the agenda as well. So there's a series of documents and things that might be of interest, and the laws that we'll be talking about today that are all attached to the agenda. These are the opportunities that we see in this diagram in front of you. So the idea that basically good quality beneficial ownership data can be combined with the information that governments and agencies on public procurement to help with a multitude of areas. So to help prevent fraud and corruption, to improve service delivery for greater competition, to verify supplier eligibility, and so all of the other things that are listed on here. This is expanded upon in the guidance, that the briefing document that I will share in a second. To explain to you what we are doing in Kenya, my team is working in partnership with the East African Tax and Governance Network on 3 things that we'll be doing over the next few months. One of them is producing a technical report looking at how Kenya's beneficial ownership data can be mapped to the beneficial ownership data standard, which my team helps to look after. That is designed to help connect data from any country, from any jurisdiction, so that if you, for example, are in Kenya and there's a business, let's say, registered in Mauritius, if everyone was producing data in line with our standard, it makes it much easier to connect up that data from multiple jurisdictions to follow the threads of where that's going. And I'm also happy to say that our data standard is aligned with the open contracting data standard, which we'll talk about later, which Kenya is already using to release its public procurement data. So we hope there's a great opportunity there to more easily combine those data sets. There's also a prototype that we're working on. We call it Bluetail, and it shows that if you do have this good quality beneficial ownership data and this good quality public procurement data, then there's easy ways that you can set up a system to flag data if there are any issues with it. Perhaps someone is, a business is registered in a particular jurisdiction that you want to flag, or someone is connected to multiple companies that are bidding for the same tender. There are ways to do that using the data. So there's a prototype that we'll be developing. And then we also want to work really closely with agencies and other people in Kenya to understand best how public procurement authorities can use this beneficial ownership data, what use cases there are, and how they really want to kind of make use of that. On that topic, I want to hand over to my colleague Leonard Wanyama, who's from the East African Tax and Governance Network. As I said, they're working with us on this project, and Leonard's going to talk to us about beneficial ownership transparency in general, and looking at that from the Kenyan context. So I'll hand over to Leonard.
Good morning, everyone. Thank you, Stephen, for the introductions. Let me just share my slide. So, as Stephen had mentioned, the East Africa Tax and Governance Network are working with open ownership on this initiative. I'll be doing a general overview because a good number of the people we've invited are civil society, and I'm also happy to see a number of industry practitioners. So my presentation will be kind of a way to build a bridge between these groups and kind of set the pace before Mary makes her presentation. So again, my name is Leonard Wanyama. I'm the regional coordinator of the East African Tax and Governance Network. And just simply to introduce the organization, we are a membership civil society organization that works with the individuals and NGOs who are interested in championing tax justice for sustainable development in East Africa. So our vision is obviously to push for fair, transparent, and accountable tax-driven, citizen-driven tax systems in East Africa. We are therefore obviously working to make and build vibrant tax justice movements across the East African region, and to enable civil society and citizens to participate a lot more in developing these policies and improving practices. Our entry point in this conversation is obviously tax inequality, where we see a lot of disparity that's manifested in issues of tax collection, allocation, and expenditure of revenues. And so when we come in and say we have a tax justice agenda, then it means that it is efforts in order to address these manifestations of inequality. And we come on the basis of human rights-based approaches in looking at how do we understand issues related to country or regional financial architectures. In this way, we promote questions of participation in policy and decision-making, accountability of processes and systems, ensuring that there is non-discrimination in the application or implementation of laws, championing empowerment for social mobility, and enhancing legitimacy by insisting on working through the rule of law. And in all this, then, when we think of a mind from Tax Justice Network, who tells us that tax justice dies in secrecy. And so the question of transparency is of vital importance in how we look at questions of beneficial ownership. And that's the means by which we enter into this conversation, and hence the essence of our partnership with the open ownership on this matter. Now, simply, what are we asking? In terms of the global financial architecture and how it is forming around the world, there are two main asks that we have. One is that countries hold commitments to the Financial Action Task Force, which is global commitments. And as listed there, you can see questions in terms of establishment of financial intelligence units, how to deal with customer due diligence, questions of how do you work around suspicious transaction reports, politically exposed person, asset declarations, defined non-financial businesses and professions. And in this case today, the questions of beneficial ownership standards. This is because, as you know, there is a lot that is happening in terms of the question of illicit financial flows. And these are the issues that have been identified in terms of how we deal with them. Secondly, obviously, is that we implement mainly these questions of beneficial ownership standards, that we ensure that there is transparency, identification, verifiability of this information, and updating the policies in place so that we can be open about what is going on in relevant financial systems across the globe. So essentially, in the case of Kenya, we are also asking for these standards and that these commitments are upheld. And then we have to ask why. Because we feel, and if we go back to the question as I was speaking of in terms of a lack of transparency kills tax justice and its efforts, is that if we don't have the appropriate beneficial ownership information out there, the anonymity enables tax evasion, it enables corruption, money laundering, and the financing of terrorism. But it also allows for tax avoidance. And in this aspect, it's down to our tax justice definition of what is illicit financial flows, because while tax avoidance is a legal practice, we add it to the question of illicit financial flows in terms of its immorality in denying domestic revenue mobilization efforts, the required fair taxes to achieve service delivery goals. And so we think that dealing with the issue of beneficial ownership is therefore closing a loophole in the system to prevent these vices. Now, I won't go into the definition of beneficial owner because Stephen had mentioned that. But for us, I'd like to highlight in terms of unpacking the question of significant influence in terms of once you're a beneficial owner, what does it mean to have significant influence? Because this is what then determines how companies are run and kind of the decisions that are made, and sometimes even the determination of anonymity, so that we don't know who controls or who benefits from the proceeds of an organization. And so for us, once an organization reaches a threshold of 20% shareholding, it means that that natural person or beneficial owner has a level of significant influence that has control over an entity. And so it's good that we unpack this so that we know beneficial owners for our relevant policy needs, whether as civil society or industry practitioners or even government. Now, from our perspective, we come into this and we realize, so what are the challenges in implementing a public beneficial ownership register? First are the administrative challenges, First are the administrative challenges, which are questions that we have to look at. What would be the cost of setting it up and running that register? What are the privacy and security risks involved in this? And then secondly, because this is changing systems, where will be the places in which there'll be resistance to reform? Is it service providers, businesses, foreign companies, or corporates that are benefiting from the status quo? And so our work is therefore to kind of navigate so that we can get to the ideal standards that we are working towards by dealing with these challenges and seeing how and where the places in which we can build consensus to improve the question of beneficial ownership. Just as an overview, these are the countries that have made global commitments to beneficial ownership transparency. The dark blue, countries that have committed to that. Light blue, countries that are partially committed. And the yellow dots are where open ownership is engaged. And so you can see there Kenya and Tanzania feature. And so for us as East Africa Tax and Governance Network, we're very interested to help in these efforts in championing for beneficial ownership transparency. So of course today, and mainly I think this is for those who are not quite familiar with the subject, more so colleagues from the civil society to whom we are trying to introduce into this avenue of advocacy. Questions of beneficial ownership come from revenue authority systems, of course, the data that they collect on your telephone numbers, physical address, email address, questions of your passport. Then also you have registrar of companies, in this case, in Kenya, the business registration services, your company records, the records you submit annually that are required by statutes, and so forth. But there's also the other side of now, as companies are engaged in public procurement, they also have to submit similar information. So how can we develop a system that tracks this from various avenues in a more coordinated way, and we get to have clarity on these issues? As I mentioned, questions of company records, so the annual reports, your founding articles, regulatory authorities, and then also the data that they submit. You can see there an image of the data submitted to the business registration services. And these are some of the questions that we'll be looking at today from the presentations by our presenters. Of course, emerging issues for beneficial ownership. Today, mainly we'll be looking significantly on issues on public procurement contracting. So how are we going to use that information, track it, collect it, and so forth? But then questions of beneficial ownership also arise in issues such as counter fraud investigations, questions of anti-money laundering, countering financial, counter-terrorism financing, asset recovery and tracing, and questions of assets, intangible or tangible assets, securities and other sophisticated markets, questions of land, vehicles, insurance schemes, financial products, services, extractive industry, and so forth. There'll also be conversation in terms of the corporate vehicles, in this case, companies, limited companies, limited liability partnerships, trusts, foundation, shell companies, and shelf companies. Shell being just companies that are kind of built for a purpose of, let's say, if it is in the case of what is popularly in the news right now, questions like KEMSA, they are just made purposefully to engage in fraud or corruption, or shelf companies that are there for a while and are just picked to do that. So I think we'll be kind of exploring what's the difference in terms of these companies and how are the changes taking place in our legal frameworks affecting these corporate vehicles. Now, in terms of the advocacy efforts towards beneficial ownership transparency, in this case, today we are definitely speaking about the register. So how are we getting towards a public register? How are we going to be verifying the details that are provided by various entities and the processes of identification? But then also there is the global side of an asset register where there's a proposal to list all assets and find a way to link them into a global system in which you can then compare and understand what does this organization do. So if a company is in Kenya working in Uganda, how will they work through beneficial ownership transparency to understand these legal entities, or working in Tanzania? I think we are still celebrating the membership for DRC, so probably they also have to join up and think of these issues as they go along, and as we continue to work together in various spaces. Now, in terms of resources, Stephen had mentioned the open ownership response to, first of all, this is the law document, the question on the consultation by the business registration services. So you can read that and get to see a number of the legal questions that they've raised, especially down to the technical items that they work on. But also quite recently, Open Ownership and EATGN made comments to the PPRA on the change of format and the template to beneficial ownership form. So you can have a look at that and maybe get to understand a bit more in terms of what are the issues at play. Thank you very much. Stephen, I don't know if I'm still within time or whether I will be taking questions at this time, but kindly guide me appropriately. Thank you.
That was great, Leonard. Thank you so much. So I think we're now going to hand over to Leonard's colleague, Mary. So Mary can introduce herself, but has been, oh, let me see, I'll just make Mary the host. Has been conducting a legal review to look at some of the changes that have been happening in Kenya during this project. So since we started last October, there have been changes to the Companies Act, the beneficial ownership amendments, and also there's other kind of changes in the wider international legal landscape. So Mary's going to talk through those to explain some of the changes and what they mean, and some of the areas that maybe still need attention and revising. So Mary, I'll hand over to you.
Thank you, Stephen. So just to briefly introduce myself, my name is Mary Ongore. I'm a tutorial fellow at the University of Nairobi. I'm also doing my doctorate at the same University of Nairobi. Incidentally, my subject area touches quite a bit on beneficial ownership, especially looking from the perspective of how that helps to stem illicit financial flows, among other things. So I'm just going to share my presentation. If you could bear with me for a moment. Okay. So I hope everybody can see my presentation. And just to give a brief overview, what I'll do is to first, Yes, to first give an indication of generally what the rules say with regards to beneficial ownership. I'll be looking at the 2020 regulations. Then after that, I'll look at the changes that were made via the 2022 amendment regulations. And then finally, I'll be looking at the international aspect. So what has been going on in FATF, particularly with regards to recommendation 24. And that will be the sum of my presentation. So to start off with, I'll just give a brief introduction. I am aware that we have people with varying levels of knowledge on beneficial ownership. So I'll try and keep it as simple as possible, just to introduce everybody to the concept. So we have the company's beneficial ownership information regulations 2020, which fleshed out the provisions for the collection of beneficial ownership information pursuant to Section 93A of the Companies Act. And here, beneficial ownership is defined as an individual having at least 10% of voting rights or 10% of shareholding, or if they exercise significant influence and control. So significant influence and control has been defined as participation in finance and financial policies of a company without having full control over said company. So in a sense, it is a little bit wider, or it tries to cover these indirect ways of influencing a company or controlling a company, even where there is no shareholding. Then, in addition to that, companies are required to collect and identify beneficial ownership information, and this information must be lodged to the registrar. Where there is a change to the beneficial ownership, then these companies are required to update the registrar accordingly. So having set the scene, so I'll just go into looking at the gaps arising from the company's beneficial ownership information amendment regulations. I think those were put out in January 2022. The first gaps that I noted is that although the regulations introduce new definitions of entities that are required to be given beneficial ownership information, they do not necessarily define what those institutions are. So for example, we have a definition of what public procurement is. We have a definition of the procuring entity, and these are linked to other legislations. We have a definition of a public-private partnership and a contracting authority, but there is no definition of a public-private partnership committee. So in that sense, it seems to be a little bit unclear. For absolute clarity, I believe that they should include those definitions within that definition within the Act, just to plug any loopholes whatsoever that may arise. Then, the next one is that there appears to be some sort of conflict or lack of clarity when it comes to an overview of Regulation 13.2a as read together with 13.6. So 13.2a requires that beneficial ownership information be disclosed to a procuring entity and a contracting authority. Okay, so a procuring entity in the Public Procurement and Asset Disposal Act is defined as a public entity making a procurement or asset disposal to which the Act applies, whereas a contracting authority under the Public-Private Partnership Act is a state department, agency, or state corporation or county government which intends to have a function undertaken by it performed by a private party. There is, however, some contradiction, because in addition to 13.2a saying that information must be disclosed to the procuring entity and the contracting authority, 13.6 says that information relating to beneficial ownership shall only be made available to a competent authority, the Public Procurement Regulatory Authority, and the Public-Private Partnership Committee. So we have different entities that are required to be given information, and the clash is, what do we mean? Is the information to be held and kept by the PPRA? Is information to be held and kept by the contracting authority and only made available? I think the issue there is just that slight distinction between who exactly is responsible for holding the information, who is to be given access, because at present it's a little bit unclear. Apologies if you hear trumpets in my background. I may be just the only one. I have them, they come to practice almost every day. So apologies for that. I can hear them in my background. So sorry for that. Okay. Next gap or issue arising is that there is no indication as to when the information will be provided. Is it provided during the bidding of contracts or after the award of contracts? At present, as it reads, it appears that this information should only be awarded upon the award, from how it reads at present. But I think it's absolutely important for that information to be made available prior to the award of a contract, because then we can say, okay, this company, no, we are not going to award a tender to this contract to this company because of who the beneficial owner is, etc. But at the moment, it's silent as to when this information should be provided. Then next, there's also no indication of how far back we should go when determining or when collecting beneficial ownership information. And I think this is particularly important when it comes to public procurement, because people can easily change the beneficial ownership of a company to suit them, to enable them to get contracts awarded to them. However, then change back once they've been awarded the contract, or just keep it and allow somebody else to have what you call to have the beneficial ownership while during the process of conducting or carrying out the work under the contract, so the tenders awarded. Then next, there's no requirement for the continued updating of beneficial ownership information. As you can tell from the slide, the next point in the slide, under the under Regulation 3.6 of the company's beneficial ownership information regulations, there is a requirement to update. However, this is a requirement for companies that are providing information to the BRS. We don't have a similar provision for updating of the data that is provided on for public procurement or public-private partnerships. Then next, we have Regulation 13.5, which provides that, notwithstanding Regulation 4, beneficial ownership information will be made available to the public and maintained by the Public Procurement Regulatory Authority in the government portal. So that is a welcome change. However, the issue is that there's no similar publication or requirement for the publication of information on awards made under the Public-Private Partnership Act. I think this is important. If we were ultimately collecting beneficial ownership information, it should be available to members of the public, and there's no reason why there should be a distinction between the public procurement beneficial ownership information versus the public-private partnerships beneficial ownership information. Other issues that weren't addressed in the amendments are what happens with foreign entities. It is understood that for now foreign entities are not are included. So what happens there? There's a bit of a blind spot. We have trusts. Information on trusts is not collected. We have partnerships as well. Information on partnerships is not collected. And these are all entities, trusts and partnerships are entities through which businesses operate, and they can be abused in order to facilitate tax avoidance, tax evasion, money laundering, and terrorist financing. Then I'm going to look very briefly at Executive Order 2 of 2019, So this executive order set out the information that should be collected as part of Kenya's public procurement processes. So this was a positive step. However, there are some blind spots. And one of them is that it exempts utilities procurement arising from, it exempts entities that provide essential utilities. It exempts procurement arising from emergencies, procurements of classified nature as provided by law, and low value threshold procurement described by law. So one, we don't know what this low value threshold is. Two, it's very ambiguous when you say procurement of a classified nature as prescribed by law. What are these type of procurements? Procurements arising from an emergency. Again, there's room for abuse there. So I think what is missing is that there's a lack of absolute clarity in terms of the entities that are exempt from providing information at the point of procuring during public procurement. Then another sort of blind spot technically is the fact that the executive order requires information to be collected on the beneficial ownership of partnerships and sole proprietorships. While this is welcome, unfortunately, if we don't have this, the executive order would classify as a subsidiary legislation, and whereas you can include provisions in a subsidiary piece of legislation, it has to be it must synchronize with the main act, the primary act itself. Okay, so you cannot introduce a provision in a subsidiary legislation that contradicts a provision in the main or the primary legislation. So that may be a blind spot, and perhaps we will need to include references, an outright reference to the need to collect partnership information and sole proprietorship information. Then we move on to look at FATF's recommendation 24. So on 4th of March, FATF, which is the Financial Action Task Force, adopted amendments to recommendation 24, as well as its interpretive note. These have already been published. They were adopted and published, and they're available on the internet. So for the next bit of the presentation, I'm just going to go through the main aspects and what the significance is for Kenya. So the first one is that there's a requirement to furnish competent authorities with current information on the beneficial ownership and control of an entity that poses a money laundering and terrorist financing risk, including foreign companies that have sufficient links to the country. So you're supposed to use, the FATF recommendation proposes that you use a risk-based approach in order to find what a sufficient link is, okay? So foreign companies, what is it that links, what links a foreign company to, say, Kenya, for us to say, look, we have sufficient links to this country and therefore we are going to require beneficial ownership information. There's some examples that have been provided, and this include instances where a company has a permanent establishment, a branch or an agency in the jurisdiction. There's also a significant business activity that is being conducted, or the presence of a significant ongoing business relationship with a financial institution or a DNFBP, which is a designated non-financial business and professions, right? Or any companies that have relations with financial institutions and DNFBPs that are subject to anti-money laundering and counterterrorism financing regulations. Then there's also entities that have significant real estate and other local investments. They employ staff, they're tax resident. So those are sort of sufficient links that are being given to guide countries when it comes to collecting information on foreign companies, on determining that, there's a sufficient link for us to collect information on foreign companies. It is also recommended that national and supranational measures should be used when conducting a risk assessment of foreign companies. And the measures could include requiring beneficial ownership information on some types of foreign created legal persons to be held. So for our purposes, like we said, at present, we are not collecting foreign companies' beneficial ownership information, but there is room to do so. I think if we were to put the mechanics in motion, a place to start would be, say, for example, branches, permanent establishments, approaching their local representatives, because they're required to have local representatives, and having them being tasked with the responsibility for collecting beneficial ownership information. Next, there's a requirement to assess the risk of money laundering and terrorism financing. And rather than just assessing the risks, we must assess the risks associated with different types of legal persons or different types of entities, and not just assess the risk, but to go ahead and the next step and make a requirement to take the appropriate steps to manage and mitigate the risks identified. So for now, we have only companies that are being required to provide beneficial ownership information. However, we also have limited liability partnerships, for instance, which are also legal persons, and they are used quite often, particularly during joint ventures. So they're used, and there's a risk at present that, be given that we are not providing information, beneficial ownership information on these types of entities, that we continue to expose ourselves to a loss of revenue through IFFs, illicit financial flows. Okay, next recommendation is that there is a preference for a multi-pronged approach. And that means that companies should obtain and hold adequate and accurate information. But not only that, the information should be held by a public authority or a body functioning as a beneficial ownership registry. And in addition, there should be supplementary measures that are adopted that are necessary to ensure the determination of beneficial ownership of a company. So these additional measures could include holding beneficial ownership information obtained by regulated financial institutions and professionals, or held by regulators or in stock exchanges. So at present, we don't have that. Companies are required to collect beneficial information and provide it to the company's registry. However, there are no supplementary methods that have been expressly identified for ensuring beneficial information is determined. And the next, we have the requirement for adequate, accurate, and up-to-date information to be held. This is not just a Kenyan problem, it's a problem with beneficial ownership registries all over the world. And this comes to, and this is particularly from the perspective of verification. How do you verify that the information that you're receiving is correct, okay? So according to FATF's recommendation, information will be adequate where it is enough to establish beneficial ownership. It will be accurate where it has been verified for accuracy, using reliable independent source documents, data, or information, and it will be up to date where it is current. So for now, we struggle. The Act does not provide for verification to ensure the information is up to date. Under the 2020 regulations, yes, companies are meant to ensure that the beneficial ownership information remains up to date, remains current, but there's no sort of way of verifying or even provision that allows for the verification of this beneficial ownership information. Next, under recommendation 24, competent authorities, and in particular law enforcement, are required to have access to beneficial ownership information, and this must be accessible for entities that engage in public procurement. So for Kenya, we somehow we comply because under Regulation 13.6 of the Beneficial Ownership Information Regulations, competent authorities are allowed to have access to beneficial ownership information, and this includes the Attorney General, any criminal investigation agency, law enforcement agencies, authorities that supervise and monitor the financial sector, including the Financial Reporting Center, as well as the Kenya Revenue Authority. So given that we have these entities being permitted to have beneficial ownership information, then yes, I think we comply with that. And then also the recent change, that allows for the collection of beneficial ownership information for entities that engage in public procurement, I think we comply. Then the next is the requirement for there to be public access to beneficial ownership information. Okay, so they've listed a number of identifiers and bits of information that should be collected. But we have the company name, proof of incorporation, legal forms and status, address of the registered office, among other things. So according to the recommendation, this information must be made publicly available, and this we're not yet doing. So the significance is that, here we have space to improve by making our beneficial ownership registry public. And this can be done through the amendment of Regulation 13.4 of the Company's Beneficial Ownership Information Regulations, 2020. Then we have under FATF the prohibition of the use of bearer shares. And again, in Kenya, we are compliant with that. Pursuant to Section 504 of the Companies Act 2015, Kenya no longer allows the issue of share warrants, and any existing share warrants were to be converted into registered shares by the 15th of June 2016. So in that regard, we are compliant. Then there's also the requirement to assess risks relating to nominee shareholdings and directorships. And these are to be mitigated by requiring the disclosure of nominee status of shares and the directorships to be disclosed, as well as disclosing the identity of the nominator. So at present, we do not prohibit the use of nominee shareholdings. They are still in place, and or directorships. However, the BRS forms do provide for the disclosure of the name of the shareholders holding shares on behalf of the beneficial owner and the name of the director appointed by the beneficial owner. So to a certain extent, we are actually compliant by requiring the collection of that information. And then finally, we have the requirement for there to be international cooperation. And this is to be fulfilled by ensuring that information is readily available and readily accessible and is publicly known, so that international or other international organizations or companies authorities from other jurisdictions would be able to have access to this information. So Kenya, at least for now, complies. There is a beneficial, there's a business, the BRS has the registry, and it's publicly available where the registry is. I think they have a website. So I think to that extent we comply. And that brings me to the end of my presentation.
Mary, thank you so much. That was very, very interesting. And really good to know about some of the areas that have been improved recently, and also some of the challenges and some of the areas that still need to be addressed. Mary, if you have some time, there's a couple of questions in the chat box that would be great to, if you have a look at, specifically about, Patricia's asking about the executive order, and there's a question from Mary as well. I appreciate you having a look at those. So what Mary was talking about nicely segues into our panel session, which is coming up now. As I said earlier, I'm very happy that we've been joined by representatives from 3 organisations who've been helping to advocate for pushing forwards the beneficial ownership and open contracting agendas in Kenya. So the representatives we have here with us today are Harriet Wachira, who's the Programme Coordinator at Transparency International Kenya, and is also the Beneficial Ownership Cluster Lead for Kenya's Open Government Partnership process. We have Charlene Migwe Kigume, who's the Senior Consultant at Development Gateway, and also works as the Open Contracting Cluster Lead for Kenya's Open Government Partnership process. And we have Benjamin Mayana, who's the advisor for Eastern and Southern African, he's the advisor for Eastern and Southern Africa with GIZ's global program on combating illicit financial flows. So I will ask each of the panelists to briefly introduce themselves, come on video and to introduce themselves and talk about the work that they've been involved with. So we'll start with Harriet, and then afterwards we'll talk about a couple of questions, and it'll be great to hear the panel's thoughts on those. So Harriet, I'll hand over to you.
All right, thanks, Stephen. Good morning, everyone. As Stephen has introduced me, my name is Harriet Wachira, working with Transparency International Kenya on a program that looks with getting Kenya and enabling policy and legal and institutional frameworks to fight corruption or against corruption in the country. And among some of the things we have done is strengthening or working with government agencies to strengthen a legal framework on beneficial ownership transparency. Stephen, did you leave it with that brief or go into in-depth on what we have done on beneficial ownership?
Just if you want to spend a couple of minutes going into some of the work you've done, that would be really useful.
Okay. All right. TI Kenya has worked on beneficial ownership transparency since late 2016, early 2017, obviously after the London Anti-Corruption Summit, where Kenya made a very strong commitment on some of the things it would do to strengthen the fight against corruption, and among that was committing to having a legal framework on beneficial ownership transparency in Kenya. So what TI Kenya did was then commission a study that looked at what the legal framework at the time and to what extent it enabled or hindered beneficial ownership transparency. And then even before the study was released, we took advantage of an ongoing conversation together, working very closely with the Business Registration Service, then proposed amendments to the Companies Act, which went through in August of 2017. And then, of course, after that, we started working on the regulations. And during this process, we discovered that the amendments that had been done to the Companies Act in 2017 needed further amendments, which is what led to the amendments in 2019 that then rolled out the legislation that we have now on beneficial ownership transparency. And of course, during that time, some of the things we did was propose the initial definition of a beneficial owner, borrowing heavily from the Financial Action Task Force. And of course, we were part of the team that developed or drafted and reviewed the regulations. And I'm glad to see Malaka is here. Article 19, Kenya Revenue Authority, Financial Reporting Center. So we're part of a team that drafted and reviewed the regulations, which then took a few more years before we could see them being gazetted and were finally gazetted in 2020. And of course, at that time, by the time the regulations were gazetted, there was an executive order which Mary had spoken to. And as she was presenting, I could then, understand why there's a disconnect, because all these laws were happening piecemeal and responding to a certain need, all being traced back to the London Anti-Corruption Summit in 2016. And of course, then as this was happening, we thought one of the ways to anchor this collaboration, or to ensure that the conversation on beneficial ownership transparency does not fall off, was to get the commitments that Kenya made in the Anti-Corruption Summit on beneficial ownership transparency, to put them in the Open Government Partnership. And we did that for the third National Action Plan, which then there was a commitment and a framework or a work plan through which, the steps we're going to take to ensure there was an enabling framework. That was the third National Action Plan from 2018 to 2020, which then, as we did a new work plan from 2020 to 2022, we then still maintained commitments on beneficial ownership transparency, and that's how TIA Kenya is the cluster lead for that. So in essence, what the Open Government Partnership does is provide a platform for engagements between private sector, civil society, and government on how to collaborate and ensure that government meets the commitments or the ambitions, or one, making government more open, and two, ensuring that the laws or the ambition for creating enabling laws are then met. And I won't repeat some of the frameworks or the issues that Mary has raised, but just to say that TIA Kenya has really been part of that conversation, and we continue to be part of the team that works very closely with government on this. I think I'll stop there, and then we can engage more on some of the issues raised by Mary's presentation and by colleagues on the chapter. Thank you.
Thank you so much. Can I ask Charlene to introduce herself and just to talk briefly about the work that she's done on open contracting in Kenya?
Great, thanks, TV. So yes, as mentioned, I'm Charlene Migwe from an organization called Development Gateway. We support institutions to be more transparent, engaging, and responsive to citizens' use through the use of data, and also just to support citizens in how they can effectively engage government through the same evidence and data use. And that's why OC is a really big part of the work that we do globally, particularly to Kenya. We in collaboration with PPRA, lead the open contracting cluster that for a number of years has been trying to collaborate to ensure. I think one of the biggest challenges we have as open contracting is a lot of our systems are in silos. So procurement has been wreathed with a lot of legacy systems. So as a cluster, we really try to push for interoperability. So alignment of all the systems to make it more efficient for governments to publish the data, and even much easier for citizens to access that data. So citizens don't have to go to different portals to access this data. As DG, we've supported currently engaging 4 counties to support them in terms of open contracting. As we all know, OC is the concept of making data available so that these citizens can support government in being more efficient and effective in the service delivery through procurement implementation. So we've supported Makueni County, who from 2019 launched their open contracting portal, and they continue to ensure the sustainability of that portal and the use of the data on that portal, even internally through setting up systems in cabinet for the uptake of the data to flag corruption issues. We supported Elgeyo Marakwet. We're just starting to support Nandi, and just as a cluster, actually, as a whole. Yesterday we had a meeting between civil society, treasury, the authority, BRS, a number of exciting people in the space to discuss integration, because we're seeing, as I said, silos. So we have county governments have their own portals, PPRA through tenders.go.ke have their own portal. So we're finally getting to a place where we can discuss next steps of integrating these portals. And thankfully, thanks to PPRA, the technical team has agreed we could start thinking about the technical assessment for that, the technical development to integrate this portal, and that would make it efficient for procurement officers in counties or other procuring entities, because PPRA mentioned that these entities have their own systems also. So this opens ways for integration of procurement systems and for data transparency across the systems in Kenya. So I think, Stephen, I shall end at that.
Thank you so much. And finally, I'm going to ask Benjamin from GIZ to talk about the work that his organization has been doing before we go into a panel discussion. So where we'll talk a little bit more about some overall questions. So Benjamin, over to you. Something funny is happening with your background for me.
Yeah, I'm trying to sort it out. So
okay.
Probably, yeah.
I can hear you, but I can just see a big boardroom.
Yeah, I'm just want to remove.
There you go.
Yeah. Yes.
Over to you.
Yeah, I think it has a way of picking by itself. Okay. Yeah, my name is Benjamin Maina, working as an advisor with GIZ, Global Program on Combating Illicit Financial Flows. And BO is one of the areas that we've been supporting as a program, not only in Kenya, but also in the Northern Republic of Macedonia. We have supported in setting up of the register. And as Harriet has spoken, and probably what Mary has shared in terms of progress made, in terms of legislation, the gaps, and the other areas that have been shared, I would like to indicate probably the areas of support that we've given as GIZ. And for us, we started the support in 2018. And this was the discussion around setting up or having the regulations operationalized. And I'm happy that also Maleka is here, who was part of the team that were actually supporting in this process jointly with Harriet and other members, and that is very appreciated. So GIZ supported this process, and we are happy that we now have the regulations in place. And apart from that, we also supported the setting up of the register. That is the e-register that now collects the information on beneficial ownership. And just to indicate that these two processes of regulations and the setting up of the register were happening parallel to each other. And we are happy that this process also managed to go through. Of course, in these two scenarios, we needed public consultation and also having sensitization around the areas of BO. And GIZ also supported those public caucuses to just get feedback and also just have a feel on what BO is all about in the country. We've gone further to support the development of a simplified guide on beneficial ownership. The guide is not yet out, but we're hoping to see it soon, whereby it will give basic information on BO, probably how to access the system, and a simplified guide. Moving forward, we're looking into probably harmonization of the laws. Mary has alluded to a number of areas that needs to be addressed, and that is also something that the BRS is working on to see that this also is in tandem with other provisions and also the FATF standards. And one of those is probably just to revise the Company Act generally to fully provide for BO guidelines, and also probably the limited liability partnerships and the other legislation that have a niche on BEO. So that is the work that we're looking into, probably engaging before end of June. And then this will also culminate into probably update of the system to also incorporate these changes as a whole. So it is actually a continuous process and is also a learning experience. Probably after setting up one or two, you realize that there is need to change one or two elements. So that is what we are working on as the GIZ on the global program on combating illicit financial flows. But of course, in all this, we'll still be calling upon the like-minded partners like Open Ownership, of course, Transparency International, and private practitioners like Malachi to continue supporting this process so that jointly we can have something that is tangible and speaks to what the standards actually provide for as a robust and a workable BO register in Kenya. So, Steve, thank you.
Thank you, Benjamin. That's very, very useful. Thank you. And it's great to hear about all of the work that's going on. I guess if you all want to come back on video quickly, I have a question. If anyone else has a question, please put them in the chat and I'll put them to the members of the team. So we've discussed some of the areas that might need addressing in Kenya, and we've discussed how quickly some of these changes have come in. I just wanted to get your thoughts about what you think the biggest challenges around beneficial ownership in Kenya. Is it a technical challenge because the information and data is difficult to use? Is it that there's a lack of awareness and more work needs to be done to kind of raise people's awareness of the laws? I'm very conscious that some of these amendments have only happened 2 months ago, so things are moving pretty quickly. It'd be great to hear what you think the pressing challenges are and the areas to look at. Like I said, is it that it's awareness? But we know, for example, that there's, I think, roughly about 30% of the countries in Kenya have submitted their beneficial ownership information so far to the BRS. But yeah, so it'd be great to hear thoughts. I don't know if anyone wants to jump in and tackle that. Benjamin, maybe I can call back on you to see if you think there's particular issues that need tackling.
Yeah, it is actually easy to point on the issues of awareness. Yes, because not everyone has been reached in terms of having a one-on-one conversation around matters beneficial ownership. But for the companies, I guess this information is also out there, but we also need to do more around probably sharing this information. And that's why we are looking into having condensed information in documents like the guide that can be disseminated to a wider view or members. But that could be one of the challenge that is pointing out to that. But of course, the other thing that we are aware of is that, yes, like Leonard mentioned, the issue of shell companies, the issue of shelf companies and so on. So there could be 50% compliance, but the reason could be that the others were shell or shelf company. That is what I can say in a nutshell. But it is a conversation that we need to keep having and probably see that all the companies are in compliance, and we also reach out to more people so that they get to comply. And with our concerted effort as a team, I'm thinking that we'll be able to reach out to many people on this. Thank you.
Great. And from open ownership side, I would agree with that. We find in a lot of countries that, yeah, it's really valuable to raise that awareness of the concepts of beneficial ownership. And so it'll be great to see that guide once it's released. Harriet, what do you think about that?
It's very popular for Kenyans to say all of the above because it really is. It really is. But first, even before we point out what the issues are, I think it's important to acknowledge that Kenya has made huge strides, and I'm sounding like government right now, but it's true. I mean, when you think about where we are at, that now it will be possible to have beneficial ownership information of persons or of companies that are winning public tenders in this country. That is a huge, huge step. I mean, Kenyans in the room will agree with me. We've all had all these corruption issues where there are whispers of who could have been behind some of the scandals. We know of a famous hairdresser and the people behind her. So now that we'll be able to have this information is a huge, huge step forward. Now, having said that, of course, the inconsistencies in the law is something that we really need to be careful with, because then it hampers full implementation of our ambitions and what we really want to achieve with opening or disclosing beneficial ownership information, and of course, ultimately, the fight against corruption and improving services to the people. So harmonization of the law is something that really needs to be looked at, and it's something that we'll definitely see in the next OGP National Action Plan. How can we strengthen beneficial ownership legislation by strengthening all those other pieces of legislation, not just the ones Mary mentioned. I think it's also important to include the Public Procurement and Asset Disposal Act and how that can be strengthened, and conflict of interest laws that are contained in Leadership and Integrity Act and Public Office Ethics Act, and how they influence or strengthen beneficial ownership laws in Kenya. And then, of course, the issue of lack of verification of the data that is shared by the companies, because at the moment it's the onus is on the companies to share accurate and information, but there really needs to be a way to verify that data, whether it's done on risk basis or whatever audit framework that needs to be adopted. That is something that really needs to be taken up by the Business Registration Service, close collaboration with the Public Procurement Regulatory Authority, and then the issue of enforcing compliance. So PPRA, and I've seen several colleagues from PPRA here, they, in as much as they have the authority to oversee and to streamline public procurement processes in Kenya, they do not have the legal muscle to punish or reward public procuring entities that do not comply with requirements to disclose information on procurement processes. So this, if we already have issues with procuring entities publishing information on their procurement processes or the Public Procurement Information Portal, you can be sure these issues will also affect disclosure of beneficial ownership data. So there is need to give PPRA and BRS powers to enforce compliance. Right now, that doesn't exist, and it's a challenge that will then affect us in the long run. And finally, on awareness creation, so that civil society organizations, citizens, and the media are able to utilize the disclosed data for, to analyze trends, understand who is getting all these public tenders, what they do, because more often than not, we end up with public services that are subpar or paid an arm and a leg for. And now with all these issues of public debt, we are actually spending a lot of money procuring items that, one, are not necessary or are subpar, or we are paying way through the nose for. And it's important that we then utilize this data that is currently being disclosed to paint a picture of actually who is ultimately. I think those are some of the things I would like to highlight now.
Thank you. Yes, and as you say, and as Mary said as well, verification is a challenging issue for many countries, because, like has been mentioned here, the information comes from so many different sources, and there's so many different ways you can check personal details, company details, that it has to be something that we look at. as open ownership, we've produced a briefing on it, but we're going to be doing a lot more work because we know this is a really key area for people to work on. And also, just building on what Harriet just said, one of my colleagues is currently working on a sanctions and enforcement briefing. So that will be putting together advice from international examples on how different countries have introduced different sanctions and enforcement regimes relating to beneficial ownership. Some of those are time limited to make sure that all companies have to re-register or have to register their beneficial ownership, and others relate to a kind of ongoing sanctions regime. So we'll be publishing those soon. Charlene, I just wanted to bring you in here as well. You mentioned the challenge of silos and around open contracting. Obviously, the topic we're talking about today talks about connecting even more silos, that we're taking data that might be held in another agency and connecting it with the open contracting process. Do you think this will help to kind of raise people's awareness of the need to make those systems connect better?
Yeah, I think it's been a challenge for many years. I think when we started our OC journey with some of the counties, the biggest gap has always been beneficial ownership for two reasons. One, when we collected use cases, the biggest challenge, and we all know, is corruption. But we are seeing corruption through internal collusion. So you're having some government officials involved in some of these companies, now bringing these companies to win bids. And two was value for money, which I found very informative, because one of the counties, we saw that because part of the procurement law says that lowest bidder has a higher chance of winning, in terms of cost, lower cost bidder. You're seeing some bidders consistently bidding for the same projects, winning a number of projects, and then they don't have the capacity to do these projects and then go ahead and really do really bad work. So are we actually getting the value for money based on some of the procurement issues we have with the laws that we have right now, and for them to identify who these beneficial owners are in these companies, to flag some of the challenges that they're having. So I think back to the silos issues and the integration, where one, access to this data through the already existing channels. So you're seeing, since counties already have their own analytics, you're seeing counties already have their own corruption risk dashboards where they're flagging key issues of corruption. That includes the one that I just mentioned, the same companies always bidding, but taking it further into who are these actual owners of these companies within these different companies, to see if there's a trend within particular beneficial owners. And in that way, taking a step further to also empower strengthen the subnationals or even other procuring entities to use this data, because at the end of the day, okay, if this data is available, what does it really mean? Are there the structures in place for entities to be able to hold these owners, these BOs accountable? What are the steps that they're taking, or is it institutionalized in the current cabinet readings, etc., to make sure that the uptake of the data? So to answer your question, yes, the beneficial ownership has been a key ask across the entities we've been engaging, and integrating it to the already existing portals they have, which already open source, would be a really great next step.
Thank you so much. Just really quickly, if anyone, any of the other participants have any questions they want to put to the panel or any of our presenters today, please post them in the chat and I will ask them. I'll keep an eye out to see if any questions get posted there. I'll ask one more. Just oh, sorry, Leonard, do you have any questions from your side that you'd like to pose to people?
From my end, mainly it's some reactions. I think I agree with Harriet. The question of grievance is something that's very much in the popular imagination on this question of beneficial ownership. And speaking to a broader audience than the experts or the technical people on this subject, of course, it's a question of local problems that are having some form of global manifestation. So if you talk about who owns the companies and what are shell companies doing, or shelf companies, and the issue of corruption, there is a grievance that ties and brings out the interests of the public in this matter. So that is generally the more popular route, for instance, for civil society when they are looking at these interests or these issues about beneficial ownership. And it has spanned a whole aspect of popular news items. So way back from a show that used to tell us who owns Kenya and kind of demystifies the ownership of companies, to coverage by organization by like Africa Uncensored on Stella's Web and how shell companies are formed, to other aspects of just looking at the train or the chain of how money is moved around. But then obviously, as this is taking place, there is the question of professionalizing a sector and harmonization of law so that you can implement these global commitments, and then also addressing these challenges that are in place. So there is that kind of dynamic, and it's good now that we can at least not only just stick to the legal questions, but also kind of in terms of informing the broader public, enabling them to see the importance of why beneficial ownership is something we should pay attention to. Thanks.
Thank you. Then we just had a question from Lola, who works for SIPE Africa. So asking the panel and everyone if any organizations have done work around gathering feedback from companies, so the private sector in Kenya, to understand why compliance levels are low, why there are gaps in compliance capacity, and the perception of the burden of regulations. Benjamin, I think your organization has done some work with the private sector. Is that correct? And
I think for that, now that we have a practitioner here, he can support in answering. We have Mr. Malakai. So Malakai, please. Yeah, because he is one of those using the system. He supports practitioners in registering. So probably he's better placed. Malakai.
Let me just allow Malakai to. Malakai, sorry, I just made it so that you can respond.
Thank you, Benjamin, for calling me out on this. My name is Malakai. I'm a practitioner. I work with corporate governance consulting, providing company secretarial services and corporate governance services to our clients. I have been involved with the business registration service, and as Harriet earlier mentioned, with TI and Benjamin's team in the discussion on regulatory reforms and the actual implementation of the BRS system to address issues on disclosure of beneficial owners. Now, we've had a lot of teething issues since we started. And one of the key challenges is that the company's registry has records dating from 1903. They've had almost 4 different systems that do not talk to each other. They've had manual systems, physical files. They've had systems that capture different information for registration of companies in different formats. So the challenge from 2017 to date has been the harmonizing of those records to have one database with all companies' data. And they're doing this through a process called link business or business verification process. This process started in 2017. And the uptake has been slow because of the status of the much older files that some of the information held by the registry for one reason or another could not be traced. There were a number of conflicts between the records held by the registrar and the records being fronted by companies as their up-to-date information. So I think from where I stand, the main challenge has been the harmonizing of the records, the older records, to bring those companies onto the new BRS platform. Now, coupled with that, BRS started developing a new platform sometime in 2017 and trying to onboard the older information onto that new platform. Now, the new platform has not been fully configured to capture all the aspects of changes that can happen within the life of a company. So, for example, it does capture, you can onboard shareholders and directors directly to the platform, but where, for example, you are doing now changes in share capital, you are doing share buybacks, you are doing restructuring of the share capital, then they still those are not in the existing platform. So that also affects how disclosure and notification is being done. But there is good news, because currently, as we are discussing this, the business registration service has developed a new verification process that when companies put in their information for verification, it is now mandatory to also provide beneficial ownership information. And if that information is not provided, then the verification process is considered incomplete, and the companies can only proceed with using the system and obtaining official search results from the register of companies once this information has been onboarded. The developer has also been engaged with effect from December last year to finish the system implementation to onboard processes that were now being done outside of the system to be done on the actual platform. So we do expect that by the end of this year, the BRS will have a very robust system that will be able to capture all beneficial ownership information in one platform. And then we can talk about how to access that information, how to share it with other authorized persons, competent authorities, to ensure that this information is available for the purposes for which it was being collected. I've said many words. I don't know whether in those many
thank you
words
so much.
there is a response.
Malachi, thank you so much. That's very, very useful information about all the work that's going on the systems. I'm afraid we've run out of time. Thank you so much for everyone for joining us today. Thank you to all the presenters and the participants that are here. Just really quickly to let you know that we, Open Ownership and EATGN, will be organising an in-person workshop in June in Nairobi at the end of this project to talk more about the work and to talk more about any developments that happen in the coming months. So I hope we'll be able to invite everyone here to keep talking about these discussions and sharing resources that will help with all of the issues we're talking about here. So thank you so much for joining us. Hope everyone has a good day. And yes, thank you so much. Okay.
Yeah, thank you.
Yeah,
Thank you, Stephen. Take care.